All right. All right. Hi, Michael. How are you?
Hello.
Thanks for joining me today. I am, for those of you watching this, Kathleen Stakem with Remax Distinctive, and I have Michael Wakefield here with me from Wakefield Law. Do you want to introduce yourself a little bit, Michael?
Yes, and thank you for having me on. Yes, I'm Michael Wakefield, Wakefield Law. We're a law firm based in Leesburg. Been in Leesburg for, since the 90s, and a small family firm. It's me and my father is Charles Wakefield. And our areas that we focus in are, between the two of us, landlord-tenant law, collection and contract litigation, personal injury, and estate planning. So we're able to cover a few areas between us, but landlord-tenant is a big part of what we do, and I think that's the issue we're going to be talking about today.
Yeah, awesome. So I entered into this whole world of being a landlord almost exactly this time last year. And thankfully, knock on wood, I've had like dream tenants. I got them into a lease quickly, and they are just ideal tenants. So I am feeling very lucky because I represent landlords all the time, and I understand that that's not always the case. So I figured I wanted to jump on with you and kind of get the down and dirty on what's going on as things have changed dramatically, I know, since COVID. And what do I need to know? What do my clients need to know that are the kind of the hot button big issues in landlord tenant law currently, and what can we do to protect ourselves? So I guess part of what I wanted to know from you is, what are kind of the top mistakes or misconceptions that you see landlords making? Because, we all think we know everything about, about how to do this. And especially my clients that are landlords that have been landlords for a long time, they're kind of into their routine of how they do things. What do you see as kind of big issues currently?
Yeah, absolutely. So Virginia historically is a landlord-friendly area. Basically, other states, there are a lot more protections and limitations, and the process of eviction is much longer in other jurisdictions. But in Virginia, historically, it was quite short. So, for example, before COVID, you only gave a 5-day notice if someone was late on rent. If they didn't pay everything they owed within 5 days, you served them with a lawsuit. And in court, their only defense would be, there are obviously many defenses they could raise, but, it's largely that you paid. If you signed a lease, the only defense is that I paid, or else maybe the house is not habitable or something like that. But it was relatively straightforward. Since COVID, that turned on its head. So there, for a long period, was a moratorium on evictions. And you just could not, except for very limited circumstances, do rent-related evictions. That has since been lifted, but there are still many protections in place for tenants because of COVID. For example, the 5-day notice is gone. It's now a 14-day notice. So common misconception is that a client will call me and they'll say, I need you to do my eviction. They're $8,000 behind. Don't worry, I already served them with a 30-day. I already served them with a 5-day. And it's like, you haven't done anything. Unfortunately, you've just wasted time by trying to take steps without talking to a lawyer first, because now I have to start over with a new 14-day. You also have to yourself as a landlord file for the tenant to receive rent relief. It's not that the tenant has to, so the onus is on the landlord to do that for the tenant. So things like that are big responsibilities. And if you file a lawsuit against a tenant without following the new laws that are, like I said, lots of people don't know, there are money penalties that you can be charged as a landlord for not following the new laws, and sanctions that you can be subject to.
Wow.
So a lot of people think, I'll Google it, or I did this in, 2005 and I can do it again. The laws have changed drastically. So the other thing is not knowing the difference between a rent-related eviction and a non-rent related eviction, which I think we'll go into a little more detail later, but it's much easier right now and shorter to get someone evicted for non-rent related reason, such as an expired lease, or let's say they're the wrong people are in the house, like if it says one person on the lease and there's a family or, several adults or something, those would be things that you could evict someone for that aren't rent related. And then those rent related protections are not extended to those tenants. You do have to do a 30-day notice for those types of issues, but so that sounds longer, but the eviction process will be shorter because of the other protections that aren't there because it's not a rent related eviction.
So then in that case, a landlord would not be responsible for applying for rent relief for their tenant.
Exactly.
That seems crazy. I mean, that seems like a step nobody would assume.
It's complicated too. It's not easy, like, filling out something really easy. It's relatively complicated, and but yeah, it's totally on the land. The tenant is supposed to do it, but you can't file your eviction until you've proven that either the tenant has or that you have tried to file it for the tenant.
Wow.
So
Wow.
yeah, but yeah, you don't have to do any of that if it's non-rent related.
So along those lines, then, are these the things that you are getting called for the most? What do you hear on your end most often as reasons for reaching out for help?
A really common one is is rent. They're late on their rent. They're constantly late, or, they're 2 months behind and they keep making promises, but, it's tough, and again, you have to sort of, everybody has their life story, but, like if you think about a tenant who's maybe had a medical issue and they're 2 months behind and they're trying to pay their current rent, and that's a struggle. And so paying the amount in arrears is just sort of really difficult, where maybe they say, like, I'll try to pay an extra $200 a month, and over a year, I've made up those 2 months I missed or something. But it's difficult because landlord, the mortgage is due every month. And it's just difficult because it is a business. People get these rental properties to be an asset and not obviously something that's draining their assets. So a really common one is rent, and either rent and arrears. The other one is like damages, where you could either, let's say you were doing an inspection or you had a handy person come and to fix something, and they say, gosh, did you know that this is broken all over the floor, or they've broken the back door and it's just like hanging on a hinge or something. So there can be damages or violations of, if there's an HOA or a condo association, that are so severe that either it's not safe anymore. I can tell you the door on the hinges has happened lots of times, where just like there's no door, or they'll have some sort of cable or metal apparatus set up on the house that violates the HOA, and the HOA is sending the owner penalty bills every month until it gets fixed. So just things like that, where they're not in compliance with what they're supposed to be doing, and landlords just sort of throw their hands up because there's an urge to be, hopefully everyone has this urge. The urge to be kind and understanding is there, but it's also a business. So people think like, well, we give them 3 months and try to get things turned around, but often then the problem has ballooned even larger after that period. So yeah, it's really smart to at least just get on the phone with an attorney, whether or not you hire them, to just say, like, here's the landscape. How serious could this get? What could this cost me now versus what could it cost me in 6 months if it's getting worse? Just to understand what your options are.
Yeah. So along those lines of being nice, I often hear, my clients will say, well, my tenant, they were just like, they were paying on time, and then they were like 5 days late. And I didn't, we didn't really think much of it. And then they started to become like a couple weeks late. And now they're like consistently a month behind, or they pay a month at the end, and that they're not gonna be able to pay the next month when it's due on the first. And so I think people do have this tendency to say like, oh, it's just a couple days. What do you recommend? I mean, how firm do you recommend landlords in a perfect world being, or how to proceed in those situations?
Yeah, I think it's really important to have a carefully written lease. So the very first thing, like before money's even due, it's super important to have a really good tenant vetting process, which is worth its weight in, gold to get a good tenant, which I'm so happy you do, Kathleen.
Yeah.
But doing a lot of research on whether they're going to be able to afford this, whether they have a permanent job or is it an itinerant job, or making sure you get the right tenant. But then let's say you even did that and you have the right tenant, but then they get laid off, or which happened to a lot of people over the past 2 years, or they get a medical issue. And so yes, maybe like 1 month they pay on the 7th when it's due on the 5th. The provision needs to be very clear in the lease when the rent is due and when it is late and what fee gets charged if it is late, because those have to be reasonable. Sometimes people will put an unreasonable fee, which is not supportable. Almost all residential leases right now are governed by the body of law in the Virginia Code called the Virginia Residential Landlord Tenant Act. And so there are limits on what you can do as far as late fees and interest. But that provision needs to be very clear, and then enforcing it is another trick, because again, there's the urge that we all feel to be kind. So let's say, they had a medical issue. It's paid on the 7th. I'm not going to charge them an extra 10%, of their rent. I'm going to waive it this month. There needs to be a provision in your lease that says, if I waive any provision of this lease, that does not mean that I'm waiving it permanently. It's on a case-by-case basis. So making sure the right tenant is there and the right lease is there is super important before this landlord-tenant relationship even starts. Because then, yeah, it's paid on the 7th 1 month, the 15th on the next, and then you're getting paid on the 15th of the month following for, 2 months ago. And it doesn't work because, like I said, your mortgage is due on the 1st or whenever you have your mortgage due.
So our
yeah.
VRLTA, our standard lease that we are using, does have that clause in there, right, about waiving.
It should. I see tons of leases, but yeah, it could be really short. All it has to say is it's usually titled waiver or non-waiver. So it's if you're waiving any of the provisions of the lease, it's not a permanent waiver.
Got it. So one issue that often comes up, and we've kind of touched on this, is how difficult it is to evict tenants. In talking kind of in previous conversations with you and just kind of thinking through things, as a landlord, your instinct is, I would like a long lease. I want a tenant that's going to commit to being there for a year or 2 years. Then I have less turnover, I have less expenses, less headache. It sounds great. Maybe not longer than that, because then you can't maybe look at rents increase and you might be locked into a rent for longer than you'd like to. But it sounds like, in talking to you, short-term leases, although they might be more of a pain, might be a better option for making sure that you have the right tenant in place for or being able to get rid of the wrong tenant.
It definitely can be. So with evictions right now, so again, yeah, the answer to that question was very different 3 years ago than it is now. So 3 years ago, yeah, I totally agree. You could have a year, 2 year, 3 year lease. You can even put provisions in there that say there will be this percentage increase in the rent each month, or this lease is subject to you signing an addendum each year, which will concern rent increases and changes to the lease. So that was very easy. But now I would say it all has to do with the risk that you're taking on. If you have a substantial mortgage and this tenant is paying close to what you owe, it's really important to think about how long you want that lease to be, because I'm a lawyer, so I'm always thinking worst case scenario.
Right.
If they just get in there and there's no rent coming, how long will it take to get them evicted? I get that question every day, is how long will it take from when I hire you to when they're out? And that's an impossible question to answer. I would say I don't have a crystal ball. I can't tell you what will happen, but the process is the appropriate notice has to be filed. After that notice is up, it's not like you go in there and grab them by their shirt collar and toss them out. It doesn't work like that. After the notice period is up, that's when you file the lawsuit. And then the lawsuit will have a return date. If they show up, they could ask for a trial. So again, those issues will get litigated. So these types of cases get priority on the docket, which means that, it'll be a couple weeks after the first return date that the trial is, rather than normal cases, which are like 3 to 6 months out. So, I would say this, if the tenant is totally unresponsive to anything, you're looking at minimum 60 to 100, to 120 days before they're out. And can you afford that if, if the rent was just not coming? So yes, I think it's important to think about that. You can absolutely do month-to-month leases with tenants where the risk is you get them in there and they could be out in 30 days. And so then you have 30 days to get a new tenant in there, which is challenging depending on the time of year. But that way your risk is super limited as far as how long you would have to go if this tenant was in your property and not paying rent. There are even 3 to 6 month leases too.
So I guess it's just kind of weighing the worst case scenarios or taking the risk on which one which one do you want to take your risk on?
Exactly. And what I get asked a lot is, can I just go change the locks? Answer is no. So in Virginia, and I think every state, you cannot do what's called self-help eviction, which is go in there and say, you're out, or wait until they're out to dinner one night and just go in with a locksmith and change the lock. Big no-no, criminal and civil implications if you do that. Whereas, in commercial leases, that may be different, but residential leases, you absolutely cannot do that.
So you've touched on kind of the overview of the 14 days to get them to pay, and then you have to file a lawsuit and yada 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 yada. So that all ends, and they're evicted. Then what? You've told that, so they're ordered to pay this money. Chances are they're not just going to fork over the money, or they would have just paid their rent 6 months ago.
Right, and the other issue is you don't know where they went. So after if they're forcibly removed by a sheriff's deputy in the eviction process, there are all sorts of things that come up. You need to make sure you're compliant with your security deposit language, whether there's security deposit language in the lease or in the Virginia code. You need to make sure that if there's any property left over in the house that belongs to them, that's properly cataloged and on video and pictures, because the worst case scenario is them saying, well, where's my antique diamond ring that I had on the counter? And it's like, whoa. So those all those issues spark when the eviction is completed. But yeah, the question I get asked all the time is, okay, I got a judgment with you, like, all right, Wakefield, you got me a judgment for $7,000 of rent, late fees, and $3,500 in attorney's fees. When do I get my check? And it's a piece of paper. That's just the court saying that they owe it. Then the situation changes from the primary goal being eviction, which has been, we've succeeded, but now collection, turning that piece of paper into money, is a whole different skill set that, again, our firm handles. So evictions traditionally, and it's the way they are, unfortunately, are hourly. Very few lawyers will do evictions on any other basis, like a flat fee or something like that. Most lawyers do it on eviction. That's how our firm does it, is on an hourly basis. So when we get the judgment and they're evicted, we can often shift it from the hourly basis to a contingency basis, which means that you're no longer paying us hourly. Our fee would come as a percentage of what we're able to collect from this former tenant. So if you have a judgment for $10,000, our fee would be only if we, for every dollar that we collect, we would hold back a percentage and disperse to you the remaining percentage, which works out a lot better for landlords, because they don't want to keep spending money when it's like good money after bad. If the tenant is, they moved to Tennessee and they're unemployed, gosh, you're not going to collect that money. So it's definitely good to get shifted over onto a contingency. But basically, we use the process we use is we have to follow the FDCPA, the Federal Debt Collection Practices Act, because when our firm is doing that, we fit the definition of a debt collector. And then we'll use tools available to judgment creditors in Virginia, which are summoning people into court to have them testify about their assets, subpoenaing their bank statements and W-2s and pay stubs, and then if it isn't resolved, filing a garnishment either on employment, so you're getting a portion of their wages, or a garnishment on their bank account where you're getting what's in a bank account. So there are aggressive collection techniques that you can use when people aren't willing to say, like, come to the table.
Right.
Most landlords that I represent are willing to talk to tenants about like a payment plan once it's shifted over and they're out of the property. So we're able to do that. But yeah, it is, frankly, the harder part, to collect the money than it is to get them evicted.
Yeah, I can imagine. That's not so easy. You brought up a good point though, in that not collections related, but you had mentioned security deposits. For me, this is something that comes up all the time. I mean, people will, the lease will be over, the tenants will move out, and then the landlords are like, okay, we're getting ready to relist this, but we need to do this, this, and this. The tenants did this, this, and this. How much of their security deposit can we keep? And that's always something that I'm like, that you're out of my wheelhouse now. This is not. But is this something that you see a lot? And what are some things landlords, I always have them take videos and pictures when they start the lease. But what do you suggest?
Yeah, a video and picture when you do the walkthrough with the tenant at the very beginning is critical. And then a video and walkthrough the second either they're, compliantly ending their tenancy, or it's, when you regain possession through an eviction. Video and pictures, and often a witness is a good idea too. Just have another person with you. So if it went to court, you would have someone else to testify, not just the landlord. But so let's say you're holding a $5,000 security deposit and you get the property back and they poured concrete into the toilet and, broke out all the windows. Yeah, all of that. Basically, what you must do is pay somebody to fix it. You can't, or you can fix it yourself, but you can't charge, unless you're a contractor, that you're using your company.
Right.
Like I'll have a landlord say like, well, I had to, fix some plumbing issues and I had to tear up the carpet and put down, new hardwood, that's like those puzzle piece hardwoods. And, I want to charge $100 an hour for 50 hours because that's how long it took. No, you can't do that. You basically, what you can do is pay somebody, or, there are a few exceptions, but you pay somebody and then you use the receipt and you take that out of the security deposit. But you have to follow the rules that are in the lease. And that's, again, a carefully written provision of your lease to say within X number of days, generally it's 45 in Virginia, but you can have, I've seen leases say less and I've seen leases say more, that says you must give them a security deposit disposition within 45 days of the ending of their tenancy. So that means that, let's say it's an eviction, you don't know where they went. So you just have to send it to the last known address, which is the address that you evicted them from. If you know their email address, you should send it there. You can even text it as an attachment. But, say $5,000 security deposit, new carpet, $1,500, plumbing work, with Mr. Plumber or whatever it is, $350. And then here's your check for the remainder. Or if it zeroes it out, then it says, or let's say it's even more than the security deposit, then you say, okay, bottom line, return security deposit, $0. You owe me $2,147 to pay the rest of the damages that you owe. And that has to go out in accordance with the lease. And if it doesn't, again, you're in the realm of now the landlord has violated the lease and could have to disgorge all of the security deposit back to the tenant plus attorney's fees. So again, like they've damaged your house worth $10,000. You're holding a $5,000 security deposit. You may have to pay the tenant $5,000 plus their attorney's fees. So it's really important to follow these rules, and again, talk to a lawyer about what you need to do in these landlord-tenant matters.
So it sounds to me like any landlord should have an attorney that they have a relationship with, that, even when things are going well, that are like, okay, remind me of what I need to do. Like I need to put a calendar reminder for this 35 days after my, lease is up. Just all these little things that you might not be thinking of, but it really is wise to have somebody like you that can kind of guide through this process
Yeah, for the same reason I would never try to list and sell my house. I would talk to somebody else who's a professional. Yeah, these aren't the issues that you should dabble in, and a lot of people do with landlord tenant because as a landlord, you are going to get a ton of expenses, and when things break, it's your responsibility. So the prospect of hiring an attorney when your tenant isn't paying you rent, it's like you're already losing money there, and now you have to spend more money to get them evicted. It's obviously, I get it, it's not a good feeling at all. But it's not the type of thing that you can just sort of fool around with. I mean, every single time I'm in court, and this is not an exaggeration, and I'm in court, between Loud and Fairfax, I mean, I'm in court 10 times or more, 10 times or more a month. Um, every time I'm there, I see a pro se plaintiff, so someone who's not represented, have their case completely dismissed for an easy procedural issue or an easy administrative issue. One of the things about the evictions right now is there's a new affidavit that it's a new paper that must be on the front of the unlawful of the lawsuit that you file. If you don't do it, your case is just dismissed.
Wow.
And it's a piece of paper you have to sign. So, it's really important to know you're not just wasting another month or 2 months or 3 months trying to do it yourself. And there are people who do and succeed as well. But it takes time, and it takes, a special skill set to make sure you're following all these complicated and always changing rules.
Yeah, no, for sure. And I feel like a lot of times they look to us as realtors for that guidance. What we're representing them in the finding a tenant and listing your home, but I don't know. This is not, I'm just thankful to have someone like you that I have referred clients to that have, every single person has come back and like, oh, we're so thankful that we were able to talk to him, and commercial clients and residential clients, and it doesn't matter. So I really appreciate your expertise and what you've been able to do for my clients, and inevitably for me in this landlord world that I have found myself in.
Hopefully you never need, I always say, I hope you never need me.
I'm
But
sure
if
mean,
people do, I'm always happy to help.
in my current situation, I do not, but I can imagine in the length that I will have this house at some point, I will need you. So I appreciate your time today and all the expertise that you shared with us, and for all the help that you've given my clients.
Of course. Well, thank you so much for having me. Always happy to chat.
Thanks.